By court. The judgment of the court is unanimous and same will be read by the president of the court. In this amended petition, hereinafter referred to as the petition, the petitioner, who was the presidential candidate of the National Democratic Congress, NDC, in the 7th December 2020 presidential elections, is seeking 6 reliefs against the Electoral Commission as first respondent and the presidential candidate of the New Patriotic Party, NPP, as the second respondent. The reliefs are in the nature of 3 declarations and 3 orders. Aside of Relief Ye, which is praying the court to restrain the second respondent from holding himself out as the president-elect of Ghana, all the other reliefs were directed against the first respondent. These reliefs are: A declaration that Mrs. Jane Adukwe-Mensah, chairperson of first respondent and the returning officer for the presidential elections held on 7th December 2020, was in breach of Article 63, Clause 3. Seemingly similar cases on the same pedestal. The big question, however, is, are the 2 cases alike or do they present similar issues for determination? The answer in both questions is a big no. It is therefore not surprising that the petitioner in his closing address filed on 23rd of February 2021 admitted the similarity in the Eastern petition and that of 2012-2013. Background to the petition. On the 7th December 2020, the first respondent hearing, the Electoral Commission, which is the constitutional body established under Article 43 of the Constitution 1992 to conduct all elections and referenda in Ghana, conducted parliamentary and presidential elections in all 275 constituencies in the country, which are made up of 38,622, from which the second respondent's declaration as president-elect was made. As a result of that, he has not presented to the court any figures to contradict the data of the first respondent. Petitioner's case simply is that the figures or data declared by the chairperson of the first respondent as the valid votes cast and those obtained by the 2 contestants, that is petitioner and second respondent, when computed, do not give the second respondent more than 50% of the said votes to merit her declaration as provided under Article 63, Clause 3 of the 1992 Constitution. The petitioner averred that the declaration was therefore unconstitutional, null and void. The petitioner proceeded further to seek an order to set aside an instrument affirming the declaration, that is CI 135, and a further order to organize a fresh rerun between the petitioner and the second respondent in compliance with Article 63, Clause 4 and 5 of the Constitution 1992. The above constitutional provisions were reproduced under Regulation 14, 1, 2, and 3, Regulation 44, 1, 2, and 3 of CI 127, and they read 63.4, where at a presidential election there are more than 2 candidates and no candidate obtains the number of percentage of votes specified in Clause 3 of this article, a second election shall be held within 21 days after the previous election. 5. The candidates for a presidential election held under Clause 4 of this article shall be the 2 candidates who obtained the 2 highest numbers of votes at the previous election. End of quote. From the nature of the relief sought in this petition, Relief B appears to be the major relief on which the other 5 reliefs, that is A, C, D, E, and F, are buttressed. The success or failure of reliefs A, C, D, E, and F depend on the success or failure of Relief B. For purposes of emphasis, we wish to reproduce petitioner's Relief B. It reads, a declaration that, based on the data contained in the declaration made by Mrs. Jane Adukwe-Mensah, chairperson of first respondent and the returning officer for the presidential election held on 7 December 2020, no candidate satisfied the requirement of Article 63, Clause 3 of the 1992 Constitution to be declared president-elect. This Relief B, as quoted above, raises an arithmetical Question: it cannot be resolved without resorting to some calculation. Even if by statistical projection, the votes of all the 128,018 registered voters in Techiman South were to be added to petitioners. They later complied when the court admonished them to do so within 24 hours or have their petition determined in accordance with the law. The petitioner, who did not file any witness statement of his own, filed witness statements of 2 witnesses he intended to rely on to establish his case. The first respondent also filed a witness statement of his chairperson, while the second respondent filed a witness statement through his attorney. Standard of proof, burden of proof, and persuasion. A petition of this nature is a form of civil litigation, and like all civil cases, the standard of proof is one on the balance of probabilities or preponderance of the probabilities. The proof prescribed in civil trials is provided under sections 10, 11, and 12 of the Evidence Act 1975, NRCD 323. These sections on the burden of proof, burden of persuasion, and burden of producing evidence 448 and Ama vs. Hydra Foam Estate Ghana Limited, referred to Supra. In the last case cited, the plaintiff did not testify in the action at all and only relied on the testimony of the court-appointed witness. Yet he succeeded, and this court considered the process valid, so long as the evidence relied upon was credible and effective. The failure of the petitioner to testify himself is therefore not fatal to his cause, as the law permits that. What is required from him by law is for him to call requisite witness or witnesses or put before the court sufficient material as evidence. Initially, the petitioner indicated calling 2 witnesses, so only 2 witness statements were filed on the orders of the court. These witnesses were PW1 and 2. After the 2 witnesses had completed their testimonies through the adoption of their witness statements and cross-examination, the petitioner prayed the court to permit him to call a 3rd and final witness to conclude his case. Though the prayer came at a time the petitioner had not given any prior indication of such an intention, for which counsel for the respondents raised objection to the move, the court obliged him and made an order for a witness statement to be taken from his witness to enable him to testify for the petitioner. The petitioner did so and closed his case with the witness who testified as PW3. Out of these 3 witnesses, the one whose testimony appeared to have some relevance to the issues at stake was Mr. Johnson Esiedun Ketia, PW1. He was, in fact, the star witness of the petitioner. His testimony vividly explained the reasons why the petitioner is in court. As for the other 2 witnesses, that is PW2 and 3, Dr. Kwesi White and Mr. Robert Joseph Metenuno, the little said about their testimonies relative to the issue at stake, the better. PW2 and PW3 were agents who represented the petitioner in the National Collation Center dubbed the Strong Room. Their testimonies were based mainly on what allegedly happened in the Strong Room during the final collation and the fact that they failed to sign the final form of the presidential election scored from 13 because of disagreements they said they had with the chairperson of first respondent and her staff in the Strong Room. They recounted a fanciful tale of how the chairperson refused to heed their complaints on some irregularities they noticed in some of the collation forms that came from some of the regions. We describe this evidence as fanciful because that's opportunity to represent petitioner in the Strong Room, and they decided to leave. They cannot complain now that the declaration was done in their absence. With respect to the duties of party agents or representatives, we refer to the Kenyan case of Amolo Odinga and another versus Independent Electoral and Boundaries Commission and 4 others, number 2 of 20th Nation's electoral system, which has deepened the grave doubts harbored by many Ghanaians about the true outcome of the December 2020 presidential elections. Ladies and gentlemen, the motto of Ghana's Electoral Commission is transparency, fairness, and integrity. Principles
that the key actors of the Electoral Commission clearly failed to live up to on this occasion. The refusal to account to Ghanaians further sets the worrying an approach of opacity and non-accountability in their work, just because they know they can rely on unconvincing interpretations of our laws to shield them from scrutiny in the near future when they are held to account. It's true the Inter-Party Advisory Committee was supplanted by unilateralism. This has not boded well for harmonious relationship with stakeholders. Compared to the two previous leaderships of the Commission,